My name is Hannah Jean S. Gardaban, Section A43, OLCPCLJ3. What is burden of proof? Burden of proof, also called burden of persuasions or onus probandi, is the duty of a party to present evidence on the fact in issue necessary to establish his claim or defense by the amount of evidence required by law. Rule 131, Section 1. What is burden of evidence? Burden of evidence, also called as onus evidentiae, is the burden of going forward with the evidence. What is the difference between burden of proof and burden of evidence? Burden of proof never shifts, and it remains with the party upon whom it is imposed, while burden of evidence shifts from party to party, depending upon the exchanges of the case in the course of the trial. What is meant by presumption? Presumptions is a rule of law stating because a basic fact exists, another fact also exists. It is an inference as to the existence of a fact, not actually known, or a conjecture based on past experience as to what course human affairs ordinarily take. What are the two classes of presumption? Presumption juris or presumptions of law, and presumptions hominis or presumptions of fact. What are the two basic types of legal presumption? Conclusive presumption, presumption juris et de jure, is one which cannot be refuted by any counter evidence. Give the two examples of conclusive presumption. Give at least 10 examples of disputable presumptions. That a person innocent of crime or wrong, that an unlawful act was done with unlawful intent, that the person intended the ordinary consequences of his voluntary act, that a person takes ordinary care of his concerns, that evidence willfully suppressed would be adverse if produced, that money paid by one to another was due to latter, that a thing delivered one to another belonged to latter, that an obligation delivered upon the debtor has been paid, that prior rents or installment has been paid when a receipt for the latter one is produced, that a person found in possession of things taken in doing of a receipt wrongful act is a taker and doer of whole act. Who can contest the legitimacy of a child born to a wife? Is the presumption of legitimacy of a child born after 300 days following the dissolution of the marriage or the separations of the spouses. Whoever alleges the legitimacy or legitimacy of such child must prove his allegation. What is the doctrine of res ipsa loquitur? State the requisites for the doctrine. Res ipsa loquitur is a Latin phrase which literally means the thing or the transaction speaks for itself.